Good afternoon, everybody. Welcome to this 39 Essex Chambers webinar on current topics in commercial and construction costs. Our speakers are going to cover these topics. Judith Ayling will talk about changes to Practice Direction 3E, the cut-off between incurred and budgeted costs and budget revision. Shaman Kapoor will talk about a good reason to depart from budgeted costs. Marion Smith QC, what you need to know about non-party costs orders. And Paul Darling QC, indemnity costs, a forgotten battleground, ? Just a few housekeeping points. This session is being recorded and the recording will be made available on Chambers' website. We suggest that you use the layout rather than the speaker view so that you can see any discussion which may take place between the panel. We encourage questions, so if you'd like to ask a question, please use the Q&A button on your screen. We shall deal with as many questions as we're able to. So first we have Judith Ayling. Judith is very well known for her costs work. She is cost counsel for UK Trucks Claim Limited in UKTC v DAF and others, in which there is a dispute as to whether a third-party funding agreement is a damages-based agreement. She often acts and advises in costs disputes arising out of other areas in which she specialises, high value and complex personal injury, and clinical negligence claims. Judith's going to tell you all about budgeting. Over to you, Judith.
Right, good afternoon, everybody. I've got 10 minutes on this complex topic, so I'm not going to speak to all the slides that I have given you. There are a couple of changes which have just come in and there are some more to come, so that's what I'm going to focus on. On the 1st of October 2019, Practice Direction 3E was amended, in particular 7.4, and the Precedent H guidance was amended supposedly to match, but I'll show you why it doesn't quite match, on the 7th of October 2019, and there's no transitional provision, so these new provisions are simply enforced. So what are the amendments? They seem small, but they're actually quite important. In the practice direction itself, and there's no amendment to any of the rules, it's just the practice direction in the guidance. The PD at 7.4 is amended to say that in paragraph 7.4, the first sentence, you amend to say that before the day of any has gone, and it's clear that incurred costs are up to and including the date of the cost management hearing. So as part of the cost management process, the court may not approve costs incurred up until and including the date of the cost management hearing. But as you'll remember, that the court may take those costs, may make comments on those costs and will take them into account when considering reasonableness and proportionality of the costs it's actually going to budget. And then the guidance was amended at about the same time, on the 7th of October, to say that incurred costs are all costs incurred up to and including the date of the first cost management order, unless otherwise ordered. And at B, it's amended to say budgeted costs are all costs to be incurred after the date of the first cost management order. And you'll all recall that it's mandatory to follow the guidance, and the practice direction itself says that. So where's the problem? And the problem is that there's a discrepancy between the practice direction and the guidance. However, what is now clear, finally, from the new PD 7.4 and the guidance, is that the first case management costs should be included as incurred costs. But of course, the new wording applies to all phases. So all of the costs up to and including the date of the first case management conference are now to go from estimated into incurred. And that means that when you're preparing the budget, the first budget, you must take great care to estimate what further costs will have been incurred in each phase by the time of the CMC. So you can't make the incurred estimated cut-off at the date when you're doing the budget. It must be at the date of the CMC. As I say, that's now absolutely clear from the practice direction in the guidance. And that's helpful if you get into trouble because you fail to file a budget in time, because the cut-off for applying the sanction for not having got the budget on time is extended up to the date of the case management order. There's a little bit of a wrinkle about that because of this case of Ayling Channel 5 broadcast, and I'm not going to go into that in detail. I've given you the relevant provisions. In the Costs and Funding 6th edition, there's an argument about when the sanction applies, whether it's from the date of the breach or from the date of the first CMO. And I just remind you quickly that if you do get into trouble for not filing a budget in time, you can begin to get out of that trouble by making an effective Part 36 offer. Again, I've given you the provisions and I won't go through them. So what are the problems about having shifted that cut-off between incurred and budgeted costs? And obviously one problem is where there's a substantial delay between the budget and the first case management conference, and that might be in a low value case. I'm not going to go through this in detail either. Obviously one solution is simply to put the incurred figures just in the bill at the cost assessment, just that's where you put the increase, but the paying party might object to that. Probably a better solution is to address this with the court and with your opponent and try and get updated budgets to the court. And certainly in any substantial case, I think that's what you're going to want to do if you're aware that your own incurred costs are out of date. What if the case management hearing proceeds on one date and cost management is put off to another day? Again, that's a situation where you're likely to end up with a black hole where incurred costs are one sum in the budget, you incur more incurred costs by the time of the cost management hearing. Where do you put them? And another problem with leaving them as they were is that the court must have an accurate picture of what the incurred costs are at the time when it does the cost management hearing, because those incurred costs must be taken into account, and that's mandatory when the reasonableness and proportionality of subsequent budgeted costs are being looked at. So again, my preferred solution is simply to ask the court for a direction as to what to do about amending budgets. Now, what's this inconsistency that I began to talk about? As I pointed out, the practice direction at 7.4 says that incurred costs up to the date of the case management hearing, whereas the guidance says the first case management order. What if you have two costs and case management hearings? And just another strange anomaly, the guidance also says that incurred costs are as defined unless otherwise ordered. I'm not quite clear where that came from, and it certainly hasn't been explored in the case law yet. And I've just pointed out, it's on the slide, there's a bit of a glitch in one paragraph of costs and funding, a tiny thing, but just be aware of it. So the problem is when you come to need to revise a budget, what do you do with costs that have been incurred since the date of the first cost management order before you get to the point of the court making the second cost management order, where the court can only permit variation in respect of future costs? So what does it do with that, again, black hole of incurred costs since the previous cost management order? Now, the White Book guidance at 3.15.4 says that if you revise a budget, estimated costs that were previously estimated don't magically turn into incurred costs by the time of the next case and cost management hearing. And it says its advice is in terms that if you submit a revised budget, leave the incurred costs where they are. And of course, the guidance says that the cutoff between incurred and budgeted is the first cost management hearing. I keep saying case management hearing, it's of course cost management hearing. So the cutoff in the guidance is the first cost management hearing. That's not so clear, as I've shown you, in the practice direction, which just refers to the cost management hearing. Now, the cases are inconsistent on this as they stand at the moment. So in Yo and Times newspapers, Mr. Justice Warby was asked to look at budget revision, and the application was to add £21,000 worth of incurred costs on a new issue which had arisen since the last cost management order, and £15,000 for future estimated costs. And he looked at the wording of 7.6, which says that the court is to approve, vary or disapprove revision of future costs having regard to any significant developments which have occurred since the date when the previous budget was approved or agreed. And he said that para 7.6 is not an act vehicle for obtaining the court's approval for costs which were incurred before the budget. So he couldn't look at those incurred costs and be asked to approve them, because the practice direction just doesn't allow him to do that. So that's Mr. Justice Warby. But in this case of Sharp and Blank, in a very detailed, clever judgment from Master Marsh, he took a very different view. And this is huge group litigation where the first CMO was made after the second CCMC. There's a big black hole of costs which had been incurred since the first CMO. And he said that future costs applied to costs after the last approved or agreed budget. So the effect was that he stopped the incurred costs clock running at the point of the first CMO, and any costs after that were future costs. So he was turning incurred costs after the last CMO into budgeted costs. So that's inconsistent with the decision of Mr. Justice Warby. So this remains a hugely tricky issue, is all I can say. And the Civil Procedure Rules Committee is very aware of that, and in fact is going to do something about it. So I will just finish by showing you what's about to happen insofar as I can, because it's not all in the public domain at the moment. So in October of last year, the Civil Procedure Rule Committee looked at this whole issue of staged budgets, which happen in big cases, budget variations, what it called budget repair, and planned budgets. In December 2019, with the senior cost judge there at the meeting, there was further discussion of what was going to happen. There's a new precedent T, which is to deal with budget variations. There was a proposal for a budget variation notice, which in my view would be a good idea, so that you tell the other side in the court what you're about to do, and then updated guidance notes. Now, in fact, at that meeting, the precedent T, this new precedent T for variations, was agreed in principle. It was resolved not to adopt a budget variation notice, and the revised draft rules were then to go to the Feb 2020 meeting. And in March 2020, the Rules Committee agreed amendments to 3E, which will essentially replace the present PD3E, which I've talked through the most recent revisions. It's going to go, and there will be a new version. A precedent T for budget variation will be introduced. And what the Rules Committee minutes say is that this revision of the practice direction will not be accompanied by the existing additional guidance note. So what's envisaged, and I have no access to the detail of what's going to be in the 3E, but everything will go into the practice direction rather than the anomalous situation we've had at the moment, or the anomalies created by the fact there's guidance and the practice direction and the rules. So subject to final drafting, and obviously subject to now to any COVID delay, there will be a new practice direction and possibly the rules in October 2020. So we will update you on the website when the wording of all that is made available. So I've talked you through the changes to date. I've given you what I can about the changes which are about to come in. And with that, I will hand over to the next speaker.
Thank you, Judith. I've got a question. I wonder if you can deal with it. Rupert Jackson was convinced that the only way to control costs was to budget them at the outset. Do you think he has achieved his aim?
Well, in my view, the biggest difficulty remains incurred costs and controlling incurred costs, and something, in my view, has to happen to the protocols, the pre-action protocols, for there to be more control over incurred costs. I think that's all under discussion also by the Rules Committee. My own view is that budgeting has to a large extent worked, but I think revision remains a significant problem, and obviously that's the thing that the the next thing that the Rules Committee is going to look at.
Thank you very much. We'll move on to Shaman Kapoor. Shaman's practice covers several fields of commercial and common law, and his cost practice bridges both of those fields. He's frequently instructed for his opinion as an expert in costs in the SCCO in protected party cases. He's also an accredited mediator. He sits as an arbitrator and adjudicator on the 39 Essex ADR panel for civil liability claims. He's also a deputy district judge and sits in southwest London. He's going to talk about good reasons to depart from budgeted costs. Shaman.
Thank you, Peter. Right, folks, we've got to go into turbo mode because I've never seen the former senior cost judge so menacing about council's time estimates. So, got to get moving. Right, here we go. CPR 318B says, when assessing costs on a standard basis, the court will not depart from an approved or agreed budget unless satisfied that there is good reason to do so. So the question is, what is a good reason? And it seems to me 5 cases merit what I call a tequila shot review in these next 8 to 10 minutes. So, Henry and News Group, Newspapers Limited, I think perhaps slightly close to our chairman's heart, 2013 went up to the court, Court of Appeal. It dealt with the first pilot that was introduced under the CPRC to control costs in defamation proceedings. Now, it is true that the pilot had slightly different terms to the CPR as it now stands, but nonetheless, there are a number of general principles that are worthy of note. Firstly, if the costs incurred in respect of any stage fall short of the budget, to award no more than has been incurred does not involve a departure from the budget. It simply means, according to the Court of Appeal then, that the budget was more generous than was necessary. Now, note that point, please, because there is a U-turn coming in years later. The next point that they noted was that it is necessary to take into account all the circumstances of the case, but with particular regard to the objective of the cost budgeting regime. They said that there was no need for an exhaustive definition of good reason to be provided, to which, of course, cost lawyers rub their hands with glee. And then they went on to say whether there is good reason to depart from the approved budget in any given case is likely to depend on, amongst other things, how the proceedings have been managed, whether they have developed in a way that was not foreseen when the relevant case management orders were made, whether the costs incurred are proportionate to what is in issue, and whether the parties have been on an equal footing. The respondent in that case had first sought details of the current cost position before making an offer for settlement, which came to be agreed. They did not protest when they got the up-to-date cost position, and so it was the Court of Appeal found that there was a good reason to depart in that case. Okay, 1 down, 4 to go. Second, Thomas Pink Limited and Victoria's Secret UK Limited, 2015. High Court judgment of Mr. Justice Burse in the Trademarks Court. The parties had agreed and submitted cost budgets to the court without any attendance and failed to ensure that a CMO had in fact been made. But notwithstanding that, when it came to deal with the costs, the court was content to apply and did apply CPR 318 anyway. The receiving party sought a further £50,000 and on their application for a good reason to depart provided evidence of why there was an increase. The evidence spoke to these reasons. Firstly, they said, the trial started a day later than anticipated and a day in the middle of trial was added for written submissions, all of which increased costs unexpectedly. Further, they said there were unanticipated costs of dealing with the judgment itself, and then, of course, this application having to be made for good reason, which has also caused the costs to increase unexpectedly. And in fact, the court there found that there was good reason in those circumstances. The other reason why that case is interesting to note is because it also dealt with an application for payment on account of costs. Now, I appreciate that's not really the remit of what I'm to speak about, but it is a noteworthy case because it seems to me to be the first one in what then turns out to be a long line of High Court judgments, essentially establishing a rule of thumb that on incurred costs, 90% is about right for a payment on account of costs. There have been other cases subsequent, in the TCC in particular, a case of Cleveland Bridge UK Limited in 2018 and others after that. All right, 2 down. Third one, Sony Communications International AB and SSH Communications Security Corporation, 2016, in the Patents Court before Mr. Roger Wyand QC, sitting as a Deputy High Court Judge. Now, this was the trial of an action for the revocation of a patent brought by Sony against the patentee SSH. Cost budgets had been approved, but the parties unusually agreed that there was no need for a detailed assessment and had requested a summary assessment instead. Claimants sought increase to phases, experts, trial prep, and trial by relatively sorry, I'm checking messages in case I'm going on. Trial prep and trial by relatively large margin. And the court held that each phase of the budget needed to be considered separately. There had been a good reason to depart from the budget on the experts' report phase. This case had in fact involved scrutiny by the experts of a larger number of documents than had originally been anticipated. And the defendant's own budget for this phase was about 100,000, I think, euros, more than the claimant's budget for the phase. And although the claimant was noted to have failed in its duty to seek to vary its costs budget, the defendant had not been taken by surprise by the overspend in the claimant's budget for this phase. The court emphasised that there could not be a combination of phases so that an underspend in one could be compensated by an overspend in another, and thus trial prep and trial could not be two phases that would be simply fused together. In the end, there was no good reason to depart on the trial prep phase, but there was good reason to depart on the trial phase. Another sidebar note for why this is an interesting case is because the court there, again, dealing with summary assessment, but before summary assessment, had considered making an issues-based costs order. And in the end, what it did was to apportion the costs of the unsuccessful issues across the phases by a percentage reduction. So it's quite an unusual case and one I would commend to you to read. So that's 3. The fourth, very quickly, Merricks and Heart of England NHS Foundation Trust 2017, High Court case, Mrs. Justice Carr's decision. She held that a good reason is required for both an upward and downward variation in a budget sum. Spending less than was approved or agreed in the budget would require a departure in order to comply with the indemnity principle. And this has been more recently followed by His Honour Judge Dyte in a case of Barts Health NHS Trust and Salmon in January 2019. And of course, complying with the indemnity principle, having spent less, means that in the end, you're opening up those costs to assessment on the more conventional basis, i.e. a line-by-line assessment, or in fact, a broad brush assessment if that is what the costs judge opts for. But it is to be noted that that was where the underspend still appeared to be too high for the work done in an incomplete phase. That was Merricks. The last shot then is Harrison and University Hospital Coventry in Warwickshire, NHS Trust 2017, another Court of Appeal judgment. It's noteworthy that at first instance, Master Whalen in the SCCO found 2 things. Firstly, budgeted costs do require a good reason to be shown in order to depart from them. And secondly, he found that incurred costs held a certain status because they would have featured in the mind of the budgeting judge, so that in practical terms, good reason was also required to depart there. The Court of Appeal held as follows: budgeted costs do indeed require a good reason to depart, much like the rule says. Further, that the application of the indemnity principle is of course capable of being a good reason for departing from the approved budget. And that is the U-turn that I alluded to right at the start. It seems to be inconsistent with what the Court of Appeal found in the Henry case. The Court of Appeal went on to say that cost judges should be expected not to adopt a lax or overindulgent approach to the need to find good reason, if only because to do so would tend to subvert one of the principal purposes of cost budgeting and thence the overriding objective. The robustness and relative vigour of the approach on CPR 3.9 applications for relief from sanction can properly find at least a degree of reflection in the present context. And again, they made it clear they were not proposing to set out a full list of what would be a good reason. Two final points on that case. Incurred costs do not require a good reason to depart from the stated figure and shall be the subject of detailed assessment in the ordinary way. They do not fall within the ambit of CPR 318. And finally, they referred and were reassured by the fact that proportionality always stands in the background across all of costs as a further safeguard. Just concluding thoughts, I promise, Peter, just 6, I hope, swift points. Firstly, I haven't touched on hourly rates due to time constraints, but suffice to say that there is divided opinion on whether hourly rates allowed on incurred costs opens the door to a departure on budgeted costs. Second point, applications for good reason should be rare and are discouraged. Third, once good reason is established, then the thinking is that costs judges will deploy a broad brush approach akin to that of the judge at the CMC rather than the conventional line-by-line assessment. Fourth, the TCC considered that the trial judge has authority to indicate for the benefit of the costs judge that there should be a departure from the budget, although it considers that the trial judge should be slow to do so. That's quite an interesting case, and it's the case of Car Giant Limited and Marion Burgess of London Borough of Hammersmith, 2017. Fifth, costs judges, for their part, would welcome the assistance and consider there is Court of Appeal authority, in fact, to say that trial judges should assist in that way. And they cite North Star Systems Limited, a Court of Appeal case from 2006, and a further Court of Appeal case, Drew and Whitbread, in 2010. Final point, closing sentence, applications for varying a budget prospectively should be more commonplace. Thank you.
Thank you very much, Shaman. I'm actually, well, congratulations on almost sticking to your time. I'm going to ask you the same question as I asked Judith. Rupert Jackson was convinced the only way to control costs was through budgeting. Do you think he has achieved his aim?
I think he has, in large part. I think his aims would have gone deeper and further to some extent, because not all of his recommendations were accepted, as we know. But it's quite interesting that the current volume of Cook on Cost, the authors there seem to suggest that maybe it's dawning on the profession as a whole that the penny's finally dropping, and in fact, just as we've seen in the review of the cases that I've just done, the penny seems to be dropping. The rule means what it says, and in fairness to you, Peter, I didn't have a chance to say, but I think you saw the writing on the wall when you dealt with the Henry case. You went, I think, further than what the strict terms of the pilot that was governing that case had prescribed. But in fact, you, I think, were dealing with the way in which you understood the process ought to work. And in fact, the rules that subsequently came in after that have somewhat, I think, paid credence to what you had said at first instance. But anyway.
Well, in regard to that, the Court of Appeal has spoken, so it's not up to me to tell them where they went wrong. Thank you very much, Shaman. We now come to Marion Smith QC. Marion has extensive experience in representing and advising clients in Europe and the ASEAN region in a broad range of commercial and construction matters. She's also regularly appointed as a neutral dispute resolver, arbitrator, adjudicator, and expert determiner. She's Deputy Chair of the Chartered Institute of Arbitration's Trustee Board, pardon me, and the International Committee of the Bar Council. She lectures at Queen Mary University, London. She's a professional fellow of Aston University and is a contributing author to Global Arbitration Review's The Guide to Construction Arbitration, 3rd edition, 2019. She is consistently ranked in the leading legal directories and is described in one this year as, quote, technically superb, great at very complex matters, and very personable, unquote. Marion's going to tell you what you need to know about non-party costs orders. Marion.
And I've managed to avoid being that panelist that failed to unmute themselves. That's a first. Lockdown, week 14, and I finally learned. Good afternoon. Costs against non-parties, anecdotally on the increase. Can I ask you to do something for me, because we have no data? All we ever do is deal with it anecdotally. Would you go into the Q&A box and will you tap in either yes or no? Yes, I have applied for a third-party costs order or been the subject of one, or no, I've never applied and never been the subject of one. Would you mind? We'd like to get some stats on this. Interesting. Not the blanket no that I thought, coming up as yes, threatened recently, number saying that they've got one on the go at the moment. My personal belief is that, yes, threatened, is that, and we'll talk about threats in a moment, you're not supposed to threaten, you're supposed to warn. My view is that it'll be on the increase. As the global economy goes into free fall, it seems to me that the risk of an insolvent party is going to increase, and that parties who are successful and find themselves with a cost order they can't enforce against the named party will increasingly be looking for an alternative. I'm going to take just one aspect of this. There is a huge range that one could cover, and there's been an awful lot of development in the last 3 years. What I'm going to look at can be summarised in one word. It's experts. But I'm going to look at them in two aspects. I'm going to look at them in the sense of getting an order against experts under Section 51. And I'm also going to look at it in the context of funding expert evidence through commercial funders, which will take me naturally onto the Arkin cap, which has been the subject of recent case law. If I had to speak about my slightly grandiose title, all you need to know about third-party costs, I think I would talk to you about the 4 key themes in this jurisdiction. It's the exercise of a statutory discretion, and that underpins everything. The outcome is fact-specific. It doesn't matter what application you're looking at against which sort of funder or what sort of involvement. The facts matter, the nature and the degree of the connection with the proceedings. Causation, absolutely key. There has to be a causal link between the involvement of the third party and the incurring of costs. And then in relation to procedure, you have 2 mandatory elements. The person against whom you're seeking the order must be added as a party and must be given a reasonable opportunity to attend a hearing at which that application will be considered. There are 3 other aspects which are not as mandatory, but are pretty settled. Notice may be important, a notice or warning that an application may be made. The decision as to whether or not to make an order should be taken by the trial judge, and it should be a summary process, no satellite litigation. We could talk about the extent to which those actually apply, but let's get on to look at experts. Experts are crucial in the TCC and the commercial court. It seems to me that cases are decided on two aspects in those divisions. What does the contract mean? and the expert evidence. And over the last 40 years, there have been huge changes in the treatment of expert evidence. The Icarian reefer, which led into the CPR 35, stressed the importance of the expert being objective, and Jones and Caney removed the expert's immunity. But as we know, we still have experts who either didn't get the memo, didn't read the email, or other expression you want to use, don't get the fact that they're supposed to be objective. And there have been a stream of cases recently in the TCC in which experts have been named and shamed with their deficiencies spelt out. I won't go through the cases, we all know them. But what can you do? You can report to the regulator, you can say there's damage to the reputation, they won't act again. Can you get costs? Story starts with Phillips and Symes, many years ago now, 2004, when Mr. Justice Peter Smith, yes, him, said that if you could show that an expert had acted recklessly, irresponsibly, and wholly outside the bounds of how any reasonable expert would act, then in principle, costs were recoverable. That's how he put the test. He was saying that you're looking for causing significant expense to be incurred and doing so in flagrant, reckless disregard of the duties to the court. And that was in the context of allegations that the expert had effectively followed the check, not given objective evidence. For about the next 10 years, that case is quoted in everything that's ever written about it, establishing in principle. But there are almost no cases, and certainly none that I've been able to trace, despite the fact that Jones and Caney abolishes immunity for experts. Now, in the last 5 years, we've had a short run of cases in which orders are made against experts. The first 3, experts or similar, the first 3 involve public law family cases. So the stakes can't be higher. If the expert gets it wrong, a child could be adopted and the natural parent loses that child. That may be the start of the reason for making these orders. But I've given you in that case list, Tremiga Laboratories, where there was a human error, a one-off human error in the typing up of a report, where at the end of the day, the expert agreed to pay £17,000 worth of costs and to change their procedures for typing up reports. The next one that you've got is that was a county court decision, but don't think this is confined to county court. Re A against B, C, D, E and F. That's a case where a High Court judge found against an expert, not for negligent work, but for simply failing to submit the work on time when ordered, despite the fact that the expert had a medical condition, which meant that from time to time they couldn't perform. The judge's view was, if you've got that sort of disorder, frankly, you shouldn't be accepting a professional engagement. And the last one that I've given you before we come to the big one is recapita translation and interpreting, where the interpreter, the company that provides the interpreters, on 6 separate occasions failed to arrange for interpreters to attend in one case, and there again, that failure led to the making against the interpreters. Small scale though, we're not talking about large sums of money, £13,000. Now, Timia this year represents a significant change. This is Timia and Lancashire NHS Foundation Trust. Clinical negligence proceedings, and the costs order is into the tens of thousands. It's just short of £100,000. The facts are unusual. I'm not going to use the word exceptional, but they're unusual. What you've got is an expert who in effect forgets the Bolam test, doesn't know what it is, and is found liable for the costs since the moment when he retired from his medical practice, but did not retire from his forensic practice. He should have done both. That failure meant that the court was prepared to order costs. Can I give you just some brief points I think that you can pull from those cases? I think that firstly, there is scope for argument as to what is the appropriate test when making an order against an expert. It does not have to be the wasted costs test, but you're going to have to fight that because so far they've been applying that test. The cases are of limited weight as precedent, but they show a trend. They all turn on their facts, but they show that there's a wide range of circumstances when these orders can be made. Unfortunately, they also show that the courts are well aware that there are experts who are not very good experts, and that's not going to be good enough. But the features of some form of public interest, particularly perhaps involvement of the NHS or a statutory body like that, increase the chances that the order will be made. Now, I'm acutely aware that I am right up against my time, I think. Peter, how long do I have left? Am I over it or am I on it?
Theoretically, you have 1 minute.
I have 1 minute, that's all I need.
You've got several cases still to do.
No, I can do this. Let us go straight to the points to be taken. What we now have is that in the sphere of costs, when you're exercising a statutory discretion, policy is important. Always check that the policy that underpins the cases you're relying on remains the policy in place. We now know that there is no one blanket rule. When you're dealing with a commercial funder, you do not have to limit the costs order made against that funder by the amount that they invested. It can be more. The court will focus on the extent and the amount of the funding provided by the funder, the return the funder would have made had the claim been successful, the extent to which the Arkin cap would leave the defendant out of pocket, and the reasons why there is insufficient ATE cover in place. Because in Chapelgate, which is what we're talking about, there was no ATE cover in place. There is still scope for the application of the Arkin cap, but only in cases which are close to the facts of Arkin, which effectively means where the funder is funding a discrete part of the costs. In Arkin, they were only funding the expert evidence. I think this might lead to a reform of the right to see funding information. It highlights the importance of checking and making, where necessary, an application for security for costs, so that in fact you never get into this issue and you can resolve everything at the beginning. Will Chapelgate change the position of funders? I don't think it will. I think funders undertake detailed due diligence, and as the courts say, it's a commercial market. They're not going to be driven out of it by the risk of increased costs. Let's not forget that the Singularis Holdings decision has shown us the rewards in this area are fabulous. Chapelgate, percentage of proceeds recovered, $45.8 million US. The decision in Singularis was purely over whether or not it was entitled to a further 15.2 million, because the deduction for contributory negligence, it said, should not be taken into its account in calculating. I'm slightly over my minutes. I will shut up. Thank you very much. I'm here for questions.
Thank you very much, Marion. Just on Arkin, it seems to me it's an extremely important and fluid area. What do you see as the future? Is there going to be some sort of new type of Arkin cap, or what is likely to happen?
There is talk, insofar as I've been able to identify it, of taking a new approach in this field and not capping the contribution towards costs that you can get from the funder by the level of the contribution to the costs, but by capping it on the amount of the net investment, so that a funder who invests £1 million to fund litigation costs in return for 5 times that amount would potentially be on the hook for 4 million adverse costs order, the difference between the two. It's shaping a new just solution, which is what they said they were doing in Arkin. It's being touted as a better balance of risk and reward. Someone's going to argue it.
Thank you very much again, Marion. We now come to Paul Darling QC. Paul has established a formidable reputation as an oral advocate who's fought commercial and construction trials and appeals all over the world, both in silk and as a junior. He's been brought in to the end of cases to argue costs and has done several cases on the effect of Part 36. Adaptability and focus have contributed to Paul's reputation as a game changer, brought in to direct some of the construction and commercial world's most difficult cases. He was at Keating Chambers until 2017, and then he joined 39 Essex, where we now see him. He has a special interest in remote trials, and some years ago, I went to a Chartered Institute of Arbitrators seminar in Canterbury, and they demonstrated what we would now call a virtual trial. Paul Darling QC was in Canterbury, and a witness was, I think, in Washington in the USA. And what was being demonstrated was a cross-examination of a witness by video. And the cross-examination started, and after about 5 minutes, the witness in Washington said, "I'm feeling really threatened." And Paul Darling looked very surprised and said, "I haven't even started yet." But he's going to start now and will tell you all about indemnity costs. Paul.
Thank you very much indeed, Peter, and good afternoon, everyone. Very good to be part of this team of specialists across the specialisms. I am the wrap-up man, effectively, and whereas everyone thinks they've kept to time, that means arithmetic is not their strongest point. I shall therefore determinedly keep to time. I've enjoyed, Peter, your introduction of Marion. Unfortunately, you missed out, and it's her fault, I'm sure, not yours, her most important attribute, which is that she is editing the ADR chapter in Wilmot Smith on Construction, 4th edition, in which I am currently heavily engaged. So, Marion, please ensure the next time you're introduced that accolade is finally delivered. It's a very high-class audience today. I've spotted my instructing solicitor from the recent remote trial that I've done, so he's seen me cross-examined across a video link the same way as Peter has. And two of my colleagues from my tutorial group at Oxford, if I may say so, they must think that things have improved in the last 40 years for it to be worthwhile coming. But thank you indeed for coming. I'm going to talk about indemnity costs and where they now stand. There has been, as many of you will know, a recent decision called Levenjan or Legenvarn. I can never pronounce it, and I try very hard. It's the case about the friendly architect who gave her friends free advice on how to construct a garden, and it all went horribly wrong. There was a preliminary issue, went to the Court of Appeal. Mr. Nissen, Queen's Counsel, decided it first time around. The Court of Appeal then had a go at the preliminary issue, upheld him but modified him. There was then a trial in front of Martin Bowdry where the claim failed spectacularly, but he failed to award indemnity costs. It went to the Court of Appeal, and in February of this year, a court comprising Lord Justice Coulson, heard the name before anywhere? Lord Justice Coulson, Lord Justice Rose, Lady Justice Rose, I beg your pardon, and Sir Jack Beatson considered it afresh. This is the case to read on indemnity costs. It's all there. I'm going to talk to you quickly about 5 topics. I'm going to aim to summarise what the case says, but provide a couple of wrinkles, which it seems to me are interesting and important. First, I'm going to address why an award of indemnity costs matters. Secondly, I'm going to talk about the court's approach to these issues. Thirdly, I'm going to talk about the test. Fourthly, the relevance of the strength of the case to an application for indemnity costs. And fifthly, briefly, and I'll be running out of time by then, defendant's Part 36 offers. Why does an award of indemnity costs matter? Well, for 2 reasons, or 3 reasons, depending on which way you classify. First, it reverses the burden of proof on the assessment, but secondly, it releases you from the shackles of cost budgeting and proportionality. And therefore, in the days that my colleagues have talked so eloquently about all the problems of cost budgeting, don't worry, just get to the end and get an award of indemnity costs and you can stop worrying. But those are the reasons why it matters. There was some controversy as to whether or not indemnity costs did bust, as they called it, the cost budget. Lord Justice Coulson had previously decided that it didn't or might not. In this case, he recanted in quite elegant and modest language, accepting that he had himself previously been wrong. So we know now why it matters, and it matters a lot. Isn't it interesting how costs arguments often take a short period at the end of a very long trial, when in reality, much, much more, or sometimes and very often a very great deal, turns upon that decision. Now, second point, court's approach. First instance and Court of Appeal, first instance first. There are quite a lot of cases where the courts say, don't look at all the authorities, don't turn up with your lever arch file or whatever the e-bundle equivalent is of all those authorities on indemnity costs. Just use the well-established test. I think that's a bit harsh, because actually we want to look at the rules, the tests that you get from the authorities you don't find in the rules. And therefore you do need to see them in the authorities. And you'll see that, however, that the courts at first instance have been very keen to stress that what's important is to get the right test, to use the right words and not the wrong words. And when we come to look at the actual tests themselves, I'm going to be giving you lists of the right tests and lists of the wrong tests. The court's very much of, there's a right test and there's a wrong test. And I have to say, being told that you shouldn't recite authority, I have to say, I as a sort of lawyer always wants to have some case in my back pocket, find extremely hard. But that's the very much the first instance mood. Appeals. Now, Court of Appeal is the most dishonest place in the country, because if it's against you, it says, and I say that jocularly and with great respect, if it's against you, it says, come on, this is a question of the exercise of a discretion, and therefore we're not interested, and how could you dare waste our time appealing? If they're with you, they say, don't worry about the fact it's discretion, don't worry, just tell us what the right answer is. Now, you see quite a lot of that in costs cases at the moment. Levin John is worth reading, because what you see is the Court of Appeal being very careful to steer its way into what might have been thought to be an exercise of discretion. Certainly the trial judge, I'm sure, would have been surprised to know that his reasoning was being dissected the way that it was. Because when you look at the words, you've got a perfectly ordinary judgment. But if you look at the Court of Appeal, they criticise him. They do it in the most elegant possible way, but they criticise him for raising a point and then not dealing with it fully. For example, what the relevance was to the ultimate decision of the Part 36 offer, not being beaten. So I do think that you are seeing in the Court of Appeal a greater willingness to interfere, and that if you get an award or in favour or not in favour, either you fail or succeed, there is more scope to try and dissect the judgment than one might previously have thought. Then I come to the third of my points. Firstly, the general test. What is the general test for whether indemnity costs should be awarded? And I trolled the authorities yesterday, had a rather jolly time looking at all the different ways in which the judges had described them. And so I've got 3 words that the courts approve time after time. Out of the norm, I have to say I've always found that difficult, because how big is the norm? Is the norm a little bit in the middle, or is it like that? What is meant by normal? Second, also, yes, unreasonable to a high degree, so as to justify an award of indemnity costs. Call me old-fashioned, that sounds a bit circular to me, but nevertheless, it's often used. Something outside the normal and reasonable conduct of proceedings. Well, I'm sure we've all conducted proceedings not in a normal and reasonable way from time to time, but wouldn't expect to get an award of indemnity costs against us. But that's another phraseology that the courts use, outside the norm and reasonable conduct of proceedings. What this ultimately means, I think, is what the judge can give indemnity costs, but he thinks there should be indemnity costs because of the way in which people have behaved. You can aggregate all the behaviour together, so aggregation's okay, but the word that gets the gigantic raspberry, and Marion used it in another sense, and it perked up my interest, the fact that something is exceptional is not the test. Marion used it in a different context, but the word exceptional, it doesn't have to be exceptional to get an award against you of indemnity in your favour or against you indemnity costs. And there's no need for dishonesty or moral turpitude. I have to say, if there was, then one wouldn't get these sorts of orders very often at all. But you see this trend of, if you put it this way, it's okay. If you use those words, it's not okay. And you see this even more in the fourth of my 5 points in relation to the strength of the case, where the strength of the case was such as to justify an award of indemnity costs. Court of Appeal gave one instance of what the right test was and two of the wrong. The right one, i.e. what was the appropriate test to apply, should the case have been seen by a reasonable claimant as to be so speculative or weak or thin that it should no longer be pursued. Again, with no discourtesy, that does strike me as a bit self-circular, but nevertheless, it is the test that they clearly apply. Hopeless in hindsight, no, don't do that. Hopeless in hindsight's dead wrong. There was obviously an anguished correspondence between the court and counsel about the difference between those tests. Lord Justice Coulson refers to it, and he said he's quite clear that hopeless in hindsight is very different from should the case have been seen to be so speculative, weak or thin, that it should no longer be pursued. And the judge in that case thought that the fact that there had to be a trial in order to resolve the issues wasn't the right test either. So yes, so weak, speculative, etc. Yes. Hopeless in hindsight, no. Needs a trial, no. Here there is one of my two wrinkles. The first, in case you missed it, was about the Court of Appeal being an interesting place to try and get a productive place to try and get appeals going for indemnity costs. Here, Lord Justice Coulson relied, when showing that the claimant had in fact seen that their case was so speculative or weak or thin, by the fact that as the case progressed, they made a lower Calderbank offer for the amount they're prepared to accept, and therefore inferred from the claimant's lower Calderbank offer a recognition that their case was speculative, weak or thin. With no discourtesy to the learned Lord Justice, I think that's a bit harsh, because there are all sorts of reasons why people make lower Calderbanks. We all know that you may just want to get rid of the case. You may have no different view at all. But I think it's worth remembering that your without prejudice savers to costs material is capable of being used against you or in your favour in more ways than just getting to the offer itself. And I think that when people are making offers of that sort, they have got to have half an eye on the fact that a judge might rely upon that as showing a particular approach to the case. And it's worth remembering, therefore, that offers can be seen in that context. Now, I'm at my 10 minutes. I am going to say a few words about my last and fifth point, which is defendants' Part 36 offers. Leading counsel for the defendant at first instance told the judge that the fact that there was not a immediate award of indemnity costs in favour of a defendant who'd beaten its Part 36 offer, or done better than its Part 36 offer, was, I think the words he used, an obvious oversight by the Rules Committee. That didn't get as much credence either from the first instance judge or the Court of Appeal as the advocate himself might have hoped, and the court was quite clear that there is no presumption in favour of a defendant who beats their who does better than their Part 36 offer, that they get indemnity costs. However, the Lord Justice Coulson emphasised that this was nevertheless an important factor in the exercise of the discretion. And here, in this case, they were going to give indemnity costs on as many permutations as they conceivably could. But here, coupled with the weakness of the case, that was regarded by the judge, Lord Justice Coulson, as enough to tip it into indemnity costs. And indeed, one of the criticisms of the judge was he hadn't explained how that interaction worked. And they formulated the test in this way. At any stage from the date of the offer up to the outcome, was there a point when the reasonable claimant would have concluded that the offer represented the better outcome than the likely outcome at trial? So again, it's words that actually one can do quite a lot with, but in fact, when one tries to apply them, it is in no sense straightforward. My own view is that if you are trying to get indemnity costs, you get a lot of help from Legend Varn. Legend Varn is a very good encyclopedia, in my view, but equally, if you want to discover the ways to unpick it, then you can see it cites all the authorities very effectively. So it's a good primer for your skeleton argument when you're trying either to get or to resist an order for indemnity costs. So I have to say that those are the applications for indemnity costs, if you're making them, are, I think, one of the most enjoyable things to do. And when you're on the wrong side of them, they're one of the worst. So best of luck, whichever side you're on.
Paul, thank you very much indeed. We have no questions on the Q&A. If anyone has any questions, please don't hesitate to put them up. I was going to ask you, Paul, I remember a case, I can't remember the name of it, unfortunately, but an order was made against defendants who tried everything they could to avoid having to pay it. And an application was made to the judge at first instance that there should be an order for indemnity costs against the defendant because of the way they behaved. And from memory, the judge said, well, there's nothing exceptional about this. This is what most defendants do. And he refused to award costs. It went to the Court of Appeal, and I think they probably reversed it from memory.
Yes, but it's a good illustration, because all you're doing is not playing with words, but it's words on both sides. And what's exceptional in the TCC won't be exceptional in my other favourite court, the South Shields District Registry. It is, and I do disagree with the suggestion that you don't cite authority, because actually, when you look at some of these cases, particularly in the Court of Appeal, I know they're illustrations of a discretion, and I understand that. However, when you see them worked through, then and what people are willing to regard as acceptable, not acceptable, in Legend there was a whole litany of procedural failures on both sides that Martin Bowdry was willing to regard as not out of the norm, and the Court of Appeal were quite happy to go along with that. So I think what's the norm is actually very difficult.
And Peter, if I can chip in on that, because it's exactly the same theme you get in the third-party costs order cases. They say time after time, really, other cases, very limited. But how else do you get a feel for where they're going to draw the line? I think they're key. And I think a good example from a previous decision really can help persuade, particularly with a new judge or a reluctant judge or a too busy judge. Wave it around in front of them.
I think that's right, but I also think that if you're asking for these sorts of orders, I'd rather be asking a long experienced judge, a recorder on his first day.
Unfortunately, we don't get to choose our judges yet, do we?
It reminds me of the marvellous story when I was in the Court of Appeal, and my opponent said to the Lord Justice Tuckey, amongst others, this is a decision of His Honour Judge Humphrey Lloyd, a very experienced construction judge, and indeed a world-leading specialist construction judge. And Lord Justice Tuckey leant over and said to him very kindly, well, Mr. Palmer, I understand that, but I always think that when someone says to me, Judge X is a very experienced judge in this area, should I ring up the court administrator and say, does Judge X do many of these sorts of cases? And when they say yes, is he any good at them? So I do think that actually experienced judges are more willing to make robust orders and justify them and be right. And I also have a suspicion, the Court of Appeal are going to be having me up for all sorts of things this afternoon. I also have a suspicion that the Court of Appeal, that when you are applying for permission to the Court of Appeal, there are some judges from whom it is easier to get, some judges whose judgments it is easier to get permission from than others.
That's the first round of appeal, a decision with Mr. Justice.
And experience, I think, now that we have to do these things on paper, presenting the experience of the judge in a way that doesn't offend Lord Justice Tuckey's ringing up the court manager process is, I think, quite an important forensic point.
Yeah. I think we've got a question, Peter. Is there a question?
Yes. This, I think, is probably directed to Judith and Shaman. Does cost budgeting really take account of the balance between the solicitor's professional duty, i.e. giving best advice and avoiding professional negligence, and their duty to the court. And then the problem of doing everything as quickly as possible and in the shortest form of drafting. At the time we're required to cost budget, more is unknown than is known. What do you want to say about that?
Happy to offer a view. It's a bit of a blunt one. No, cost budgeting couldn't care less, quite frankly. Cost budgeting is directed to what is reasonable and proportionate cost, and that is it. The framework within which we are operating is that it seems to me it somewhat doesn't matter what the market dictates as to the true cost of running a case. The concepts that the court have to deal with are reasonable and proportionate, and that is it. One would hope that there would be an adjustment, I think, of the experience of judges as to what the market is dictating these days in order to found their assessment of what is reasonable and proportionate. But at the moment, particularly over the last 7 years, I think those are two very different cogs, and they're not at all in sync. That's my thoughts.
Judith, you want to say anything? You're muted, Judith.
Sorry. I think one thing that it's always important to remember is that there is a big gap between solicitor own client costs and budgeted costs. And as long as you give good advice to your client, that if they want a Rolls-Royce service, absolutely they can have it. And the court can't intervene to stop you paying for that Rolls-Royce service if that is what you as client want to do. But there is a gap between that and what may be allowed on budgeting. But providing there's been good comprehensive cost advice, there's nothing wrong with that. My sense is perhaps rather different from Shaman's, which is the judges, as they've got to grips with costs budgeting over the last several years since Jackson, have got a feel for what a going rate for certain kinds of work is, and that's what they allow. And then that's why I think it's working better than some people thought it would, because broad allowances are being made. It's up to the solicitors then to do the work within that broad allowance. And we know that the courts are quite reluctant to allow good reason at the detailed assessment stage to depart from what was allowed on budgeting. So I think that it's bedding in, as I've said, and that solicitor and client budgeted gap is very important. That's not to say that I don't think there are some real problems with it, because I think there are. And I've dealt with a lot of cases where incurred costs have been huge. That's my particular bugbear, as I've already said. But overall, I think the gap is manageable.
Can I just add? I think that part of the reason why I think there is this sort of disparity between what the market is actually doing and what is being allowed is somewhat reflective in this. And I know colleagues here know that I've got this sort of bugbear about the sort of guideline hourly rates that get bandied around. And it seems to me that it kind of underpins the complete misunderstanding of what the market is doing and what is being awarded. And I think that is really the essence of why I say there is that difference. But there was one other thing that was mentioned at the end of that question, which seems to have jumped off my screen, but it was to do with, or it got me thinking about the need for more and frequently more applications for variations of budgets, which I think both Judith and I spoke about in our talks. And of course, parties are to be encouraged to use the rule, use the procedure to make those applications in order to pick up the slack of things that were not foreseen at the time of budgeting. So that is something to keep in mind.
Thank you. Well, there's one more. It's not really a question, it's a comment. Does Paul have a story for every issue? You needn't answer that, Paul. If you don't.
No, well, I should have. I've not had one yet.
Good. Well, thank you to all our speakers and to all of you, our audience. If there are any questions which we've not answered or which occur to you later, please email them in either to me or to the individual speaker, and we shall endeavour to answer all of them. Thank you all again, and good afternoon.
Peter, just before you depart, could I say
Yeah.
thank you on behalf of the speakers to you for chairing it. It is very nice for us having you in Chambers, and the fact that you've chaired this is something we greatly appreciate.
That's very
Absolutely.
kind. Thank you. Thank you all. Goodbye.